Our Justice Thursday conversation begins now. So we've got the COP conversations happening in Baku, Azerbaijan. But also here, we have to continue having conversations about how climate change is impacting very many things, especially land use and conflict on land. And that's why we have the presiding judge of the Land Division of the Environment and Land Court, the Honorable Lady Justice Lucy Mbugua, with us. Judge, good morning.
Good morning.
How are you?
Well, I'm fine.
Karibu sana.
Thank you.
Yeah, it's good to see you here. And now, because of this Gen Z era, where we can call you Your Ladyship, my lady, or you guys in the court.
Any will do. Any will do.
Karibu sana.
You guys.
Yeah. So you guys in the labor court decided, not labor court, but the Environment and Land Court, decided let's actually create divisions, a division for land and a division on environment. You're heading the division on land.
Yes.
So we'll talk a lot about what your division is doing. But first, CT will welcome you with the day's proverb. CT,
yes, please.
Where are we this week?
We are in the Republic of Kenya.
Okay.
Yes.
At least that one, Justice Mbugua, that one you're okay.
Yes, our proverbs for the whole of this week are in the Republic of Kenya, And one of the things that we wanted to do was to ensure that it is truly Kenyan. If we look at the many communities that are Kenya, the one unifying component is our language, Kiswahili. Everybody identifies with it, and it is the language of Kiswahili that we are going to use. If you see me prolonging the introduction, it's because I'm looking for the page where I wrote the proverb.
It's a very short proverb, Judge.
Yes, but looking for it is taking long.
But it has been... Have you found it?
I have found it.
Very good.
Okay. I will want you to tell me what you think it means. But before that, I'll want you to tell me what you think the translation is in English. Okay? Nyumba njema sio mlango. Nyumba njema sio mlango.
A good house is not the door.
Good. That is direct translation. Excellent. Now, what do you think it means, Justice?
What you see on the face of it does not mean that the inside is the same. That is, to me, what is the meaning. I don't know whether I've tried.
No, you put it beautifully. Simple and to the point. What you see isn't the whole story. Yes.
There's more.
There's more to it.
There's always more. Yes.
Don't judge a book by the cover.
Don't judge a book by its cover.
Don't judge a house by its door.
Don't judge a house by its door.
Definitely.
Yes. And don't judge a radio talk show by his spectacles.
Hey, yes, Judge, for those who've been living under a rock until this morning, please tell them what first the Environment and Land Court is, and then the Land Division.
The Environment and Land Court was created out of a craving by the Kenyans towards the 2010 Constitution. The Kenyans wanted a dedicated court which will hear their land and environment matters, because these are issues which are at the heart of the Kenyans. You know, land is everything. Whether small or big, it is very, very important. But in Kenya, because of the various problems, including economic problems, political problems, legal problems, land and environment issues were difficult to litigate upon. But now the dedicated Environment and Land Court, upon its creation, was able to handle those disputes, those conflicts in a specialized manner, such that the court does not handle all these other cases, traffic, succession, commercial. We just deal with land and environment. And for environment matters, they affect the earth, the global earth. So they even need more special attention to be fast-tracked, to be done quickly, because if that is not done, it affects everyone. That is why the court was created. And in July last year, we also felt the need now to go further and have specialized divisions. So we have the land division, and the Environment Division, such that now land matters are not mixed with environment matters and vice versa. If you have an environmental dispute or a development dispute, it will be fast-tracked in that division without being mixed with land matters.
Okay. Who are the litigants? Who are the folks who are coming to the land court or to the environment court?
To the land court, I would say it's everyone. The big, the small, the corporations, the individuals owning even kiosks, and the ones owning tracts of land. Those ones come to the land court. But for the environment court, you'll find that it's more limited to, let's say, the developers, the people who are building high-rise structures, the class actions where there is need to do some large litigation. But the common citizen, they don't really come to the environment division so much. And that is why we are now trying to bring a lot of awareness about that division, so that the human rights issues, environmental issues are taken care of in a more speedy manner.
Why don't they, previously, historically, have they not come to the court from your understanding?
The environment
court matters. Why don't they bring them to court? And if they don't, where are they going?
Well, what I would say is that the environmental issues or conflicts, they don't seem as if they affect the common mwananchi. You know, the common mwananchi is more concerned with what affects them as an individual. My plot, my 50 by 100 plot. But when it is flooding occurring somewhere in Mathare, maybe they feel the government will take care of that issue, or some NGO will take care of that issue. So there is not so much the need to deal or to litigate on environmental matters as much as it is in land matters. Yet.
So land matters is people who are having disputes over Kamugoda. Someone just feels, huyu amesongesha beacon, huyu ako na title ya shamba yangu. Matters of succession on land, right? And those are many then, in terms of the various cases that come in on matters of land. Are there people who come to court on matters of land use?
Definitely.
Example, for example?
For example, the people who are the developers, the people who are developing lands. Let's say now it's in a residential area, but they would want to put up commercial buildings, those high-rise buildings, and there's a conflict because people in that area, they would want their area to remain as it is, and they see these new developments will affect the outlook of the whole area.
And such matters. So what is the application? That we do not want, because it's not a change of user, is it? We do not want, this area to move from low level, maybe up to 3 floors, going up to 7, 8 floors. What would the justification for such an application be? It can't just be Mr. Kimutua niangalia kiwa kwa balcon na niko kwa nyasi yangu.
There are many things the court will look at. Let's say, for instance, the court will look at the available infrastructure, the sewer system. So if it's a place where there is no sewer system, but you are bringing developments which will have human traffic, which is a lot, increased human traffic, you have to consider such things. If they are, what else can I say? Even water, if the availability of water. So it's a case-by-case basis.
Okay.
When we've had issues of in some of the more affluent estates in this, no, not really. We've had them in literally every estate we have in this town and probably the country, where it's a residential area and someone wants to establish put up a cultural establishment where there's very loud music, they're selling alcohol. Do those cases come to you as well?
They go to the Environment and Planning Division, but that is part of the Environment and Land Court. So they do come to us, but in that particular division. So the Environment Division is Environment and Planning.
Okay.
It encompasses issues of environment as well as planning.
The task or the duty bearers, those who are supposed to ensure that ordinances and laws and rules are followed with regards to the use of land or the use of property in such areas, that one is nestled with the county government, is it not? It is them. Now, this is what I find strange. The establishment is put up. It is there. It's there for a number of days, a number of weeks, even a year. Then there's a complaint. Now, I want to ask the question of public participation. In cases such as this, when clearly the use of that land has been changed, and there are people living around it, they see it coming up, they have no issue, and later they have an issue. If this matter comes to you, what exactly will they be complaining about beyond the noise? Because they saw this thing coming up. It's not as though they didn't. Nothing was done. Nothing was said.
There are many things that can come up in between the time of the development was put up and when the complaint is arising. Maybe the issue you have mentioned, the public participation, it was not meaningful. And people come to realize that what happened, they actually did not participate in the setting up of that establishment. So they will raise the complaints. Or perhaps the establishment itself mutated whatever they were supposed to do. Maybe they were to put up a restaurant. Then suddenly they have the discos, they have the, nightly activities that go on into the night. So many things can happen. There are very many varying factors to be considered.
How radical can the court get? Because here we are saying that, all right, here public participation did not happen, or that a development has gone up, for example, that is far outside what it was originally offered to be. How radical can the court get? Can the highest judicial officer in this court say, well, then this building must come down, for example?
What I can say is that a case has to be considered on what evidence has been availed. So we can't go looking for more evidence beyond what is presented by the parties. We rely on what is brought. But what the Environment and Land Court is doing, we are now leaving our chambers, going outside to create awareness. For instance, now the conference we are having on 25th to 29th of this month in Eldoret, just to create awareness about these matters of environment and having collaborative approaches with the actors, the county government, the national government, the professionals, the communities. That way now it's a sort of an educative platform where now people are more aware, such that now when they come to court and they're presenting evidence, it will be more, can I say, reasoned, and the court will be able to give a more reasonable decision. Yes.
We are witnessing something changing about our land use across the country. Okay? So more and more people are moving from where they originally stayed and going and buying land elsewhere and putting it into different use, commercial agriculture, and going into big-time agriculture. And neighbors start complaining. This person came and bought a couple of acres here in our neighborhood, and they've decided to go into big-time agriculture, which is using a lot of pesticides and all. They have sunk 4 boreholes on each corner of the plot. They are then also spraying a lot of pesticides, and we feel that it's affecting us. And secondly, we have owned this land for long, and we have left it bare and barren. He's come and put in a fence, an electric fence, that is now also affecting how we graze our livestock. Such kind of conflict. Person has bought that land, they have title, they have right to that land, but then their community has a problem in how they are using their land. Is this a land issue? Is it an environment issue?
Sometimes it can be mixed grill. Now, like the example you have given, and all the judges in those divisions, they have jurisdiction to handle the cases. So the cases can be handled by any. The dominant issue will be considered. But it will not be an issue as to where the matter can be handled, because the judge has the jurisdiction to handle the cases even if they are mixed grill.
Okay. We are having our Justice Thursday conversation this morning, and the Honorable Lady Justice Lucy Mbugua is our guest. She is the presiding judge in the Land Division of the Environment and Land Court. She's here to talk about the role of the courts in addressing climate change, and also to create awareness about this conference that will be happening from the 25th to the 29th of November in Orodoret, where they'd like you to come and interact with the officers of the court so you can get to understand what's this court about. The judges will be there, and the officers from this particular court will be there to explain to you the kind of cases that they handle. And if there's been a matter that's been going on for long, you can bring it to their attention. Judge, sasa hii kesi yangu mjamaliza na huyu mtu bado anaendelea kulisha ng'ombe kwa shamba yangu. Mnataka nifanye nini? Takata hii ng'ombe. City of a couple of questions.
I do.
Start with number one.
Well, number one, beyond the situation room, what other efforts has this court made to alert and to inform the citizens of this wonderful country of the services that you offer? I say this because if there's one subject that is touchy to Kenya, this land, it is touchy. It doesn't get touchier than that, land. All manner of things go south where land is concerned. And yet I think there are many people who actually don't know, don't even understand, that actually it isn't as difficult as they think, that they actually can go to a court in this country or courts in this country where that matter can be resolved.
Thank you. I wholly agree with you. And that is why the court is leaving the chambers. And it has been doing so for quite a while. Like in 2022, we had another conference similar to the one we are about to hold in Kilifi. It was called ELC at 10. It was a very big conference at Pwani University in Kilifi, where we invited very many people, over 1,500 people. And we had breakout sessions where citizens can ask each and any question that they feel they can ask in that environment, which is not a courtroom. You know, in court, you can't go asking a judge various questions. But there, in such a setup, you are at liberty to ask any question. So we held that conference, and it was very successful. And we had some kind of communique with the government, where we are trying to collaborate with the government in various sectors. And this is now sort of a follow-up, only that we have picked now a different topic on climate change.
Does the judiciary have a communication department?
It has, yes.
And this is what they're supposed to do?
You see them, they are in communication department. For us, there is something we want to communicate about the legal issues, that which affects the common man.
Yes. You know, I asked the question. It is very interesting that very many government units and entities have a communication department. And yet the one thing that we constantly complain about, the government doesn't communicate effectively. And yet they have a department. So it's not that I'm going to ask the question, what do they do? No. The question I'm asking is, the only way people will feel comfortable in uptaking the services our courts offer is if they are familiar with their courts. If they are not, then the myths and misconceptions around courts will persist, and people would rather find other means of solving their problems other than going to the courts.
In fact, you have hit the nail on the head.
Yes.
This kind of platform that we are going to have, it's a familiarity exercise.
Yes.
Where somebody can be close to a judge, be close to a professor, But in ordinary circumstances, that would not happen. And they are at liberty to ask anything.
Yes.
So it's a very good platform. And we are not restricting anyone to participate. Nevertheless, the participation is by registration. I've even given those details to your people here so that people can register, although just few slots are remaining. But we are not restricting anyone, meaning even the villager can attend the conference.
Do you give the information that you've given to our people here at Standard Group to vernacular radio stations as well, or vernacular media houses? I ask because sometimes people are very comfortable consuming information in a language that they were born with and they're familiar with. And the vast majority of us, when someone speaks to you in a language that you consider your mother tongue, somehow the message tends to sink quicker, faster.
That is true.
And it's more readily and easily acceptable.
That is true.
Yes.
In fact, we have already flagged out a station called I think it's Chamge.
It's called Chamge.
Chamge, because now it's in Wasengishu.
Yes.
And another one, I've forgotten the...
There's one called Berur. It's actually just next door here.
Okay.
Yes.
Okay. Even that one we shall explore because we still have time.
Yes.
Yes.
Okay.
We are intending to, as much as possible, to come to the FM stations.
Okay, I read every now and then, and even as we go through the papers, and we read stories of land cases being adjudicated, and I look at the number of years sometimes in these land cases, and I'm flabbergasted. It's been in court for 30 years. It's been in court for 20 years, even 5 years, and I feel like, oh my goodness. So how come some of these land cases, especially, take so long? I mean, 30 years. Why do they take so long?
Various factors, as I had mentioned. You know, if things were streamlined, we would not be having disputes. But this is a situation where even where the records are supposed to be kept, maybe they are no longer there. So following up on the issue, it becomes difficult. And the owners, the claimants who are following up on those issues, sometimes they even die. So you'll find that you cannot continue with the case until the legal representative comes on board, who may also die in the process, and the other one now, the next legal representative also has to come on board. So there are very, very many factors. And especially where there is the issue of fraud, let me say, fraudsters have a way of ensuring that there's a conundrum. The cases are convoluted. So they go on and want you to proceed. There are very many factors, let me say.
And did this court and its jurisdiction fall under, I remember now when we talk about access to justice and now the push from the Chief Justice to see that cases were adjudicated in a shorter period of time. Did this fall under did that directive come to this court as well?
It did come to this court, and in fact the court is strategizing on how to go about it. One of the issues or one of the strategies we are undertaking or we undertake is to flag out the old cases. Let's say, let me give an example of our court, Milimani. We flagged out cases which are over 10 years old, ensured that we have fast-tracked them. So unless there is a very big reason as to why that matter cannot proceed, like now when somebody is deceased, the case must proceed. Those cases are known. We have flagged out the ones of 10 years to 5 years, like that. They are in groups. So wherever we are having meetings, we know how many cases are remaining, which are over 10 years old. And we take deliberate steps to ensure that these cases are finalized. Such that now the cases which are very fresh, they are at the bottom of the barrel.
I know you've said, Judge, that when you're sitting at the bench, you are not going to look at a litigant and see, all right, I think you need to get some more evidence here and there. You can't start directing someone. You need to bring me extra evidence. You deal with what they've brought. But I think in some cases, well, in many cases, particularly in the land court, you have dealt with issues of double titling. You have dealt with issues of fraud, right, in land transactions, which point to the same office, the lands office, the lands registry, whether it's the National Land Registry or the county registries. Is it not possible for the court to come up with orders that then impact on how those registries are managed? Because you keep handling very many cases. It's the same issue. Nilienda pale and I did my due diligence, and when I went to check, I found that this is a legit, and then this other person is saying, I went, in fact, here's a receipt, and I paid for it, and there's a stamp from a government office. But you can see it's the same thing that's happening. The rot is elsewhere. It's not between these two people. It's actually a third entity that's to blame. Can the court do something?
Yes, the court is actually doing something. The court can summon the officers who are entrusted with those records, and we do summon the land registrars, the surveyors, to come to court and explain what is happening, which is the correct record. Another way we are devising is to collaborate in a multi-sectoral approach. For instance, now in Milimani, we have established something called a Land Justice Working Group. It is a task force under the Court Users Committee. It is a specialized group consisting of the stakeholders in the land justice sector. We have the Ministry of Lands officials, the AG, we have the surveyors, we have the lawyers. We come together and try to find out what is the root causes of all these land problems. Why have land conflicts been so rampant and persisted for decades we are dealing with the Nairobi County, not the entire country. So, and we are hoping that what we are doing will cascade and will be taken up in the entire country. So we are holding public participation activities with the GAO, that is the national government, with the counties, and we try to what we want to do is to come up with solutions. If it's policy recommendations that we can come up with. This one was, the group was launched on 5th of February this year. So I can say it's at the infancy stage. But we felt we could not just sit in our chambers and deliver judgments, which we are seeing that, you deliver a judgment, but after 3 years, it's as if it mutates or resurrects. Another dispute, which is in the same subject matter, comes up. And you still have to deal with it before perhaps you dismiss it or something. So we felt there is something that needs to be done or communicated. And instead of having, instead of blaming each other or writing in your judgment that you are blaming this person, it's better you sit together in a round table and see what is the problem and how can we come up with a solution. We have not reached that part of recommendations, but we are headed there.
Your Ladyship, that's a long route. And the problem is corruption at the land registry. Even the land ministers have said this many times before. There have been attempts at, digitizing the registry and all this, and all of them are flopping because of sabotage there. Can the court not issue orders that fast track the cleaning of the house at the land ministry? The house is a mess. And it wastes a lot of... You don't even sleep many hours because you're writing a judgment, which is similar to one that you wrote last year, which is similar to one that you're going to write next year.
Corruption is a big thing. Fraud is a very big thing. And the people involved in fraud and such things, they operate in darkness. They don't like transparency. So some of these forums that we are having is to have transparent processes, accountable processes. So, and I can say that myself, I have even gone to those land registries. We've been going around, even to the Ardhi House and some other place they have at Survey of Kenya, just to see how their processes are done. And we want to come together and see whether we can have a solution, a one-shop point where people can get documents, lodge documents, some like a court registry that is digitalized. Yes.
There, we are seeing more and more cases involving landowners and local authorities, county governments. Kiambu is a case in point. It's been in the news, right? So, you own land in Kiambu, you've applied for subdivision, for development, and then the county government puts a caveat and says, no. Hii shamba ni ya wananchi. Hii shamba iende kwa such matters where the dispute is now between a government and an owner of the land who is developing this and even has buyers on the side. How do you handle such?
We handle in such a way that the fallback is the constitution. So every land in Kenya, as per the constitution, is defined in 3 categories. It has to be public land, or private land, or community land. And there's paper trail or documentary evidence to show that. So there is no way a government can come and take away private land just like that, just by saying. There has to be some kind of evidence, paper trail, the origin of that land. So that is what we follow. So if it is private land, unless it is a case of acquisition, that one of acquisition for a public purpose, the land cannot just be taken like that. Yes.
But then there this the inroad being used is the route being used here is, yes, it's private land. We agree. But it's private land that needs to have public interests embedded in it in terms of the land use. For example, ensuring that public facilities, you set aside public facilities, police station, schools, health centers and health facilities. How do you mix those? It's my private land, but I'm being told to set aside areas for public.
For this.
Yes.
I think that is something that has always been with us. When you are subdividing your big chunk of land, I think it was accordation that you surrender a piece to the government. So this is not a new phenomenon. That one has been there. I cannot pinpoint the actual section of the law, but it's something that has always been there. Where the land is quite expansive, that you surrender, it becomes one of the conditions to be allowed to subdivide that land.
There's something that has made headlines in the recent past, and it has to do with the leases that expire on property. If I am the holder of that particular lease, what are my rights? When that lease expires, does it mean I then forfeit the land? What is it that then happens?
So that one, you have the preemptive rights. Now the law is there. If you are the owner of the lease, you are the one who has the first right to get it back.
What does that mean? That's where it gets tricky. When you say first right, what do you mean, Justice?
Or that somebody else, unless you fail to apply, if the lease expires and you just sit pretty, the land is no longer yours. Because the head lessor is there, the government of Kenya. So it will revert back to the government and the government can give it to somebody else. It moves away from private to the other category. I mentioned the 3 categories. So what you're supposed to do is make the application for the renewal of the lease. And you just get it back unless the government needs that land for a particular public purpose. You are the one who is supposed to get that land back.
See why I ask?
But you have to apply.
We read, we hear of cases of individuals who have done exactly that. They have applied. But somehow that land then ends up with someone else's name. Perhaps that falls into the category of what we're referring to as corruption within the particular, within RV House.
Yes, that does happen. And that is why we are there, to hear those cases. Those incidents are there.
This is still evidence-based. All of this, just like you said, that anything that comes before the court then must be, whatever side must be proven. We have many cases again of lost documentation. I don't have a particular deed, I was never issued this, and if the land was taken away. In the cases where there is loss or damage or inability to prove, how does the court handle what would be a natural occurrence? Maybe somebody stole it, maybe somebody grabbed the thing, or maybe I had it, but really naturally it went missing.
Yes.
How does the court handle that? And we're not talking about the ones that go missing by human intervention. Those are when we've heard stories of files going missing. But how then do you handle those, which seem to be quite rampant as well?
Again, I can say it's a case-by-case basis. There's more evidence you look at other than documentary evidence. Let me give an example like possession. If you are the one who has always been there, you've put up an industry, you have even put up a stone wall. If we go to the site, we can see the wall is very old. There is a borehole which is also very old. You've always been there. But this new person who is insisting the land is his, he has never stepped there. You see?
Nobody knows him.
Nobody even knows him. The neighbors have never seen him, but he's flashing a title. So there are many factors to be considered.
Wait, so tell us again, what's happening from the 25th to the 29th?
So it's the Climate Change Conference that we are holding in Eldoret. I told you that the other one we held in Kilifi.
Yes.
So you can see we want to be as inclusive as possible to reach
Go
out
across the country.
Yes, across the country. We don't just to be here in Nairobi.
Yes.
So from 25th to 29th at Moi University Law School, Annex Complex. So we have invited eminent persons who know these matters, because we are not experts ourselves, the judges. So we are looking towards a platform where we shall have knowledge sharing with these eminent persons, with people in the professions, and even with the communities, even the students. We are even having moot courts as a pre-conference activity, where some universities will come and participate in moot court competitions.
Right. That's going to be an interesting one.
Yes.
I wish you all the best. From the 25th to the 29th of November, the Climate Change Conference in Eldoret by the Environment and Land Court. The Honorable Lady Justice Lucy Mbugua is the presiding judge at the Land Division of that court, the Environment and Land Court.
This is the Situation Room, the only way to start your day.